Autumn is an elder law attorney with the firm Bertsch and Bose. They are a local firm that's been in business for, what, almost 30 years. Wow. So Carol Bertsch started this practice, and Brennan came on as partner in January. And so Autumn is also an elder law attorney, and she's an amazing speaker. If anybody needs her to come and speak at your civic group or speak at your faith community, she loves to speak and present, and she does an amazing job. So I'm going to turn it over to Autumn. Please welcome Autumn Puckett.
Thank you. Thank you, everyone. So happy to see all your faces today. Okay, so we're going to talk about Medicaid. So I know that for most of us, we want our loved ones to be at home as long as possible, and I will talk about some options for that as well. But sometimes we get to the point where we need long-term care, and that's where we can really help the families to preserve assets while also making sure mom or dad or your loved one has that long-term care that they need. So in general, I want to kind of give an overview of what elder law is. Most people have never heard of it. You think of family law, insurance law, all the usuals. Elder law is a specialty type of law that focuses on seniors, persons with disabilities, and their families. So we can do estate planning, where we can help with wills, powers of attorney, trusts. And I want to specifically point out that most people think you have to have this big estate to benefit from estate planning, and that's not the case. You can have a very simple estate with a home, a car, and bank accounts and still benefit from powers of attorney, a will, and avoiding probate. Probate is another service that we offer, which is assisting families with getting their property, their gifts, to their loved ones. And having a will is the most advantageous and cheapest way to go about that. Special needs planning. If you have a loved one who has a disability, whether they're young or old, we can help with special needs planning. And finally, what we're here to talk about today, which is long-term care planning and Medicaid eligibility. So I'm really going to dive into that today. It's very important to talk about the legal documents we're going to discuss today because they can directly affect our ability to help your family if and when that time does arise. Also, we do house calls. So if you have a family member who is disabled or even just prefers to be at home, we can come to your house as well. Is it going? I think it just died out on me. Okay. Oops, there we are. Okay, so nursing home costs are typically around $5,000 to $10,000 per month in San Antonio. That is astronomical. Who can afford that? The large majority of the population, it's completely out of reach. And earlier, as Jim had mentioned, Medicare and supplemental plans do not pay for long-term care. So if you find the need of nursing home care in your future, we're sort of at a loss. You'd have to end up spending all the way down of your, hard-earned money that you wanted to pass on to your children just to qualify for care. So we're here to help you and to advise that there are other ways to be able to do that. People are then required to either private pay. There's ways that you can stay home longer. I don't know if y'all are aware, there's adult day health centers here in San Antonio. There's one called Clear Day. They have a facility or a location off Bandera and also a new one in New Braunfels. But it's a Monday through Friday opportunity to drop a loved one off and have personalized care with other seniors. And it allows the caregiver at home who still maybe needs to work to sort of supplement that income into the home, or maybe they just need their parent to have some socialization. It's a good way for them to have a place to go for the day, Monday through Friday, and also provides that much needed respite for the caregiver who's at home. Also, other private pay would be care homes. Personalized care homes are an option. Sometimes people don't want to go to a formal nursing home care. They want to do more of a private, personalized option. And there are care homes out there that provide the service for a much smaller cost than the nursing home care. But again, if you have dementia or you have a progressive disease or diagnosis where nursing home care is necessary for safety or for other needs, then we're going to have to be in that Medicaid realm at that point because we would need assistance to pay for that. Okay, so Medicare, as Jim said earlier, health insurance over 65. There's no financial eligibility to require. You just turn 65 and you're able to start signing up for that. Regular Medicaid, that's for those who have limited means. And there are income and resources requirements, same as we're going to talk about today. But there's a special program for individuals who need long-term care, and it's called Medicaid for the Elderly and Persons with Disabilities, MEPD. So if you ever see that, that's what we're talking about today. I'm going to call it nursing home Medicaid just for short because it's easier to refer to it that way, but there's also income and resources requirements for that. So let's get into it. So nationality and residence, that's going to be the first element to qualify. They need to be over 65 or disabled or blind. If that person's under 65, they can just verify the blindness or disability and still qualify. There are income and resource requirements that I'm going to dive into today, and also medical necessity. They would need to have medical necessity for a skilled nursing facility or community, as we like to call it, and they must reside in that community for at least 30 consecutive days to qualify. They must need to be in the nursing home. A lot of people think it's the opposite. You have to apply and then go into the nursing home, but it's actually switched. Okay, nationality. U.S. citizen. You can also be lawfully admitted for permanent residence or just otherwise permanently living in the U.S. legally. Residency, you need to have intent to remain in Texas. So this is tricky. So we have some clients who they have a homestead here. Now I'm going to get into it in a minute, but homesteads are exempt in Texas. So let's say you have a single person and they're going to go into a nursing home. Some people are preparing their Medicaid application and they're confused whether to checkmark intent to remain in Texas or intent to stay because they're thinking, well, my parents probably not going to go back home. They're not physically able to go back home, but you need to checkmark yes, intent to remain, because there's the possibility one day that person can go home in Medicaid's eyes. So that's how the home remains exempt. So you're going to want to checkmark yes to that, just a little foreshadowing. And there's no length of residency required. Your parent who lives out of state can move here to Texas and can immediately apply. Another tip for you, a new change for Medicaid, if some people like to do a spend down where they can purchase a home here in Texas for mom or dad and then have that be their homestead, exempt from Medicaid. Medicaid has a new rule where the parent would need to live in the home for at least 30 days for that home to be considered a homestead. So keep that in mind when you're timing out how much to spend down for that nursing home care. Okay, so medical necessity. The person who's needing care has to require the services of a licensed nurse, 24-hour care, in an institutional type setting. So this can be a little tricky, especially when we don't know if certain diagnoses or certain conditions are going to require that 24-hour care. We are not given any guidelines about this from Medicaid, and so when clients come in and we're trying to help them qualify, sometimes there's sort of the question of, I can't really tell you if Medicaid's going to approve the medical necessity part, but dementia in general, you're going to be approved because anyone who has dementia is going to need medication management at some point. And for Medicaid, medication management is that key need that they look for as well. So that is also something to consider. Even if it's mild diagnosis of dementia, dementia alone is a medical necessity qualified. Okay, so let's get into income. So the gross monthly income cap to qualify for a nursing home Medicaid is $2,901 a month. Now, some people make more than that. They may have IRA distributions that are coming out. Maybe they have Social Security that exceeds that amount. That is okay. Income is never a barrier for eligibility. We can do something called a qualified income trust. It's a special trust. Some people know it as a Miller Trust. It's a trust that's only for your income, and it allows you to qualify and to bypass that Medicaid eligibility issue. So essentially how it works is the large majority of the Medicaid applicant's income will go to pay the nursing home. They're allowed to keep some things. So I'm going to talk about spousal diversion later, but they can divert some of their money to the spouse if needed. They get to keep $75 for a personal needs allowance. I don't know what you can buy with $75 these days, maybe one bag of groceries, but you know, whoop-de-doo, have fun with your $75. I will say it's been increased from $60 recently, so we're making some headway. Okay, and just keep in mind, income is never a problem. The person who's needing Medicaid, we can help you. I don't care if you make $5,000 a month, we can still help you get Medicaid. Okay, resources. So this is where it gets tricky. Countable resources for Medicaid. You cannot have more than 2,000 in countable resources. The key word is countable. There are resources that are not countable, and there's resources that are countable that we can turn into not countable. And I'm going to get into that in a minute. But what are countable resources generally? You have bank accounts, investment accounts, retirement accounts. Let's say you have an investment property in another state. You have mineral rights that you inherited. Maybe you have a farm, interest in a farm somewhere that you inherited from a family member. Life insurance policies, they often have cash value. So if you have maybe a whole life policy, you'll have a little bit of cash value accrued. That cash value is part of your countable resources, and that can trip people up sometimes. I've seen people accidentally thinking they're eligible. They go through the nursing home does the application. Yep, you're going to get approved, and they get denied over and over and over, and they don't know why. They come and see us, we do a deep dive, and we realize, oh dear, you have about $4,000 in cash value on this life insurance policy. You're going to have to fix that or you will never be approved. Meanwhile, they've been paying private pay in that nursing home the entire time, and a chunk of money is gone that we could have saved. So that's something to remember. If you're married, how Medicaid looks at it is they take the assets of the couple together. So it doesn't matter if you have separate property that you inherited from a family member, because remember, separate property or inherited property is separate. A little tip for you, if you inherit money from someone, please don't commingle that money with your spouse if you would like to keep it your separate property. Make sure that you put it in a separate account in your own name and don't allow that money to intermingle with your spouse. That keeps it separate property. For Medicaid purposes, everything is considered in a bowl. They put everything in a bowl, they split it down the middle, and they say the spouse who needs care, their side has to spend down to $2,000. The side the spouse at home who doesn't need care, they can keep up to a certain amount. And I'm going to talk about that in a second. But just remember, it doesn't matter what kind of property it is, separate or community, it's all in the same bowl. Okay, what are exempt resources? So we have your homestead. If you're a single person, up to $730,000 in equity. That's awesome. You would think you'd have to have a teeny tiny little home and only worth like $200,000 to qualify. Absolutely not. And here's something better. If you're married, no limit. You could have a $2.5 million farm and be married, and the homestead is exempt. They don't put a cap on married couples. Contiguous land is also exempt. So let's say you have your homestead, but maybe you bought the property next door. That's contiguous land. It's sort of connected. That's also exempt. A vehicle at any value. So if you have a Mercedes-Benz that's, $90K, and that's okay. And often, this is a great spend-down strategy. Let's say you have this old jalopy that's $5,000, worth $5,000. You have to keep putting money to upgrade it. Sometimes you can spend down and upgrade your car so that your spouse at home now has a reliable vehicle moving forward. That's an approved spend-down, and you also have the benefit of spending on an exempt resource. So you're just benefiting yourself in the process of that spend-down. Prepaid funeral plans are also exempt, up to $15,000. Just make sure they're irrevocable. If it's a revocable policy where you can get that money back or you can sort of get cash out of it, those are not considered exempt. You would have to make them irrevocable. And traditional IRAs and payout status, this shocks people. You could have $1 million in your IRA if your IRA is paying out the required minimum distribution. That IRA, the bulk of it is exempt, off the board. Medicaid pretends like it doesn't exist. They take the income that the IRA produces every month, or sometimes they'll do a yearly distribution. They'll divide that per month into 12 income payments. That goes into your payment to the nursing home. But the IRA itself is invisible. So don't worry if you have all your money is focused in your IRAs. That's actually a good thing. We want that. And if your IRA is not already in distribution status, there's things that we can do to make that like say it's a 401k, we can roll that 401k into a deferred annuity or some other exempt asset in order to keep it protected. But keep in mind, there's no Medicaid rules on this. They have not put anything in writing, but they've been sort of having this policy run for years. So we are just wanting to put that out there. There's nothing in writing, no Medicaid handbook rule about this, but they've been honoring this for many years. So we are hoping that continues. Okay, prevention of spousal impoverishment. This is a big one. So whenever you're married and your spouse is going to need care, we don't want the spouse at home to become impoverished or go into bankruptcy because they're trying to pay for care, or God forbid, the person going into care, they're the person that has all the income. Because, oh no, if all their income's going to pay the nursing home, how is the spouse at home going to survive? How are they going to pay the bills? So how it works is, The spouse at home keeps 1/2 of accountable resources up to $157,920. Everything else above $157,920 has to be spent down, okay? So remember that the spouse who's going into care, they can have up to $2,000 in countable assets. So anything in their name needs to be under $2,000. The spouse at home can have up to $157,920. Here's where we can get creative. So anything above that $157,000, we can either, I'll get into it in a little bit, but we can make those countable assets not countable. And minimum, so if the couple together has less than $31,584, you're already ready to qualify. You're ready to go, apply. You don't have to spend down anything because that's such a low amount. Medicaid understands, okay, we've reached the threshold. So below $31,584, apply. Above $157,920, you're going to have to start spending down. Okay. Oh, and let me go back. So remember, too, how everything is in a bowl and split down the middle. You take the whole amount of that and you split that in half. So I'm going to give you some examples. So let's say the couple has $300,000 in countable resources. Let's say they have investments and stocks and things like that. So the spouse at home gets to keep $150,000 because remember, it's 1/2 of that $300,000. They take the bowl, split it in half. The other $150,000 has to be spent down below $2,000 for that spouse to qualify for Medicaid at that point. If they have $30,000, well, they're below that $31,000 that I just mentioned, immediately qualify. Nothing has to be spent down. And finally, let's say they have $500,000 in countable resources. Well, we got to hit that max of $157,920. So anything above that is going to have to be spent down. So that's where we need to get creative. Okay, so here's the spousal impoverishment for income. So let's say the spouse at home maybe makes, I don't know, a couple $1,000s in Social Security, but the spouse who needs care is getting pensions and they make $5,000 or $6,000 a month. Obviously, the spouse at home can't survive on $2,000 a month. So Medicaid understands this. They allow income diversion. So the spouse at home keeps all of their income, regardless of what that is. They can have income of any amount. The spouse at home could have $10,000 a month and Medicaid doesn't care. It's the income of the applicant that they're concerned about. So if the community spouse's gross income is less than $39.48, that's the 2025 max, then more of the money of the spouse going into care can be given to the spouse at home to bring their income up to $39.48. So if you only make $2,000 a month, you can pull some of your spouse's income to yourself instead of going to pay that nursing home. So let's give you an example. So we have the institutionalized spouse who's needing care. Their gross income is $2,000. Community spouse's gross income is also $2,000. Well, obviously, spouse at home can't survive on $2,000. So Medicaid allows $1,948 of the institutionalized spouse's income to go over to spouse at home, bringing their income up to $39.48. Now your copay to the nursing home is only $52. We also forget you get to keep $75 in a personal needs allowance. So now your copay to the nursing home is $0. And Medicaid just pays everything. Okay. Prevention of spousal impoverishment when both spouses' incomes are below that $39.48. This is so awesome. We have been really able to help families pretty much save everything that they have. So let's say both families only make, $3,000 a month. Medicaid has this special formula where they determine how much more a couple can keep. It's based on a 1-year CD rate. Y'all would go snooze to sleep if I tried to explain it to you. It's a math equation. But basically what they do is they say, how much money would we need to fund a CD to produce enough income to reach that $39.48? So if they only make $3,000 a month, I need to find a CD that would produce enough income per year to overcome that $948. Well, that's a lot of money. You'd have to fund a CD with a pretty big amount to produce that much interest. So that's how they're able to basically protect more. Y'all will go snooze to sleep if I try to tell you. Okay, but if y'all want to come talk to us about it, I can break it down more specifically. Okay, spend down. So let's spend down on things that you already have and that you can keep. Repairs to your house are a big one. So let's say you have a spouse at home and they're needing to go into care. Maybe the spouse that's still remaining at home one day might need, I don't know, chair rail or wall rails like we talked about earlier. They might need a bathroom renovation for a shower that they can walk into. They might need larger doorways for wheelchairs. You can actually repair the home for the spouse that's at home for future needs as well in order to properly spend down on an exempt asset because you're increasing the equity of your house. New vehicle, as I mentioned earlier, you can upgrade the vehicle that you have. One vehicle is exempt of any value, so I don't recommend buying a Maserati or something, but you can buy something, you know, expensive if you wanted to, but be aware of insurance. Prepaid funeral plans, again, you can do that. If y'all are interested, I actually brought Funeral Consumers Alliance information. They actually partner with Funeral Caring USA, and you get discounted rates on your funerals or cremation services, like deeply discounted rates. So if y'all want any information, come talk to me later. I'll get you that. Dental work is a big one. Most of us sort of fall behind on our dental needs, especially for our seniors. That's another way to spend down. That's an approved spend down as well. But please do not gift money away. Some people think, oh, I'll just gift a bunch of money to my kids, and then it'll stay in the family, and then I can qualify for Medicaid. But that's where most people go wrong. So what are the transfer gifting rules? Most people have heard of the dreaded 5-year look back. Well, that's what we're talking about here. So a person is ineligible for Medicaid for 1 day nursing home care for every $242.13 that they transfer to someone else that was less than fair market value or just giving something away. So let's say you sold a car that was worth $15,000 and you sold it for $10,000. Well, there's a $5,000 deficit that Medicaid's going to penalize you for. And how they look at it is, if you're going to be giving money away, why are we paying for your long-term care? And I can understand that, but we just have to be very careful in how we gift. You can still do it, but there's special ways to go about that. Anything over $200 is considered a gift. That includes paying people's bills. I've had clients who have paid their children's electric bills for years, and tithing to church, that's considered a gift. So there's something that we're going to have to overcome. We can do affidavits, or we can try to explain to Medicaid that this gift done 4.5 years ago was not a gift in preparation for Medicaid or to anticipate needing Medicaid. We've been fairly successful with those, but there's no guarantee that Medicaid's going to accept our affidavit. They might just say, oh, too bad, you're going to be imposed a penalty, and we don't care that you gifted your granddaughter a car 5 years ago, or 4.5 years ago. So 60 months, they look back 60 months, and I promise y'all they will find it. I have had people try to hide bank accounts, try to hide a vehicle they gave away to their grandkid. They will always find it, I promise you. So just foreshadowing for yourself, if you feel like if a diagnosis has been received by your doctor, even if it's mild, start considering this now because it might progress to the point where you need Medicaid assistance. And it's going to be harder for us to try to explain those gifts later or to try to overcome that penalty. It's better to try to preempt it now or as soon as you are aware that the problem might be arise and you might need to make some other arrangements. And again, it can be making a down payment. I've seen so many people that just gift their car away to charity during their life. Maybe they don't drive anymore, and so they'll just gift their car, which is so wonderful. But when it comes to Medicaid, they don't look kindly on that. They'll still penalize you for it. And again, affidavit, no guarantee it'll work, but I will certainly try my best. And I write a very comprehensive affidavit on your behalf whenever I need to. So let's give you an example of gifting and what it looks like. So mom gives daughter $10,000. You divide that $10,000 by the daily rate of a nursing home, which is $242.13. That equates to 42 days of ineligibility. That means private pay. So if you've already spent all your money down to prepare for qualifying for Medicaid, how is that going to happen? Usually the adult children or family members have to step in and help pay, and that is a big, big problem for the families who are trying to help their parent get that long-term care. So a second example, which is a much more impactful example, mom gives son $50,000, divide $50,000 by 242.13, 207 days of ineligibility. That is insane. You're private pay that entire time. And if you need full-time care at that point, we've got problems. And essentially, the more you give away, the longer you're ineligible for Medicaid. So just please keep that in mind. Okay, transfer rules. So many people think, oh, I'll just gift it now, and then I'll just transfer. I'll do the math in my head, and I'll calculate the penalty, and then I'll just apply it after my penalty period runs out. That's not how Medicaid works. They've already thought ahead. So they say, well, your penalty starts when the applicant would otherwise be eligible for benefits. So after you've spent down, after you've got your Miller Trust, everything all done, and then you're ready to qualify, that's when your penalty period will begin. So they got wise to our efforts there, but it's unfortunate. Okay, so let's talk about transfer strategies. So sometimes we want to gift on purpose. because we want to be able to preserve some of our money for our loved ones. So let's say you have a single person and you want to try to give some of your estate away to your kiddos. Well, you intentionally gift. So we would purposely gift half of the resources. We know it's going to cause a penalty, but what we do is we take the other half of that money and we purchase what's called a single premium immediate annuity. We call it a SPIA for short, and it's essentially an immediate annuity that begins paying that next month. So it starts to provide a stream of income to that person that's at home or to the single person who's going to be needing care. How this works is when you're buying this annuity and you're creating a stream of income, you're starting to pay yourself a monthly income that can cover your long-term care while that penalty period is running. So you're still getting the care that you need. You've already gifted half of your estate to your loved ones, and then the annuity will time to end right at the point of when you start to need care and when Medicaid will become eligible, or when Medicaid becomes eligible for care. Okay, pros, you're immediately eligible because once you've purchased this annuity, that money's off the board. It's gone. But then there's cons. You've also spent half of your assets on your nursing care. So there's also annuity costs and fees we have to talk about. So whenever you purchase an annuity, let me back up here for nursing home care in general. There are wonderful nursing home staff who are able to do your application for you. You don't have to pay an attorney to do it. You don't have to pay these special Medicaid companies to do it. The problem is some of them don't know what they're doing. Remember the life insurance cash value I talked about earlier? That was an accident from someone who worked at a nursing home because I just didn't know. So sometimes you have to be very careful when you're having the nursing home do the application because your estate might need something a little more formal, an attorney to step in. An annuity is an example of that. Nursing home staff don't know what to do with an annuity. They don't know how to put that on the application to justify that. So you would have to likely pay an attorney to do the application, which can be several $1,000s. It's a lot of attorney time. And there's also annuity costs, probably around $2,000, I guess. But if you're saving $50,000, $90,000 of your estate, it may be worth it. So just something to consider. I wanted to make sure you have full understanding of what it costs to do these kinds of annuities. Also, too, for a single person, they would need a power of attorney that has those gifting powers. I'm going to talk about that in a minute, but if your loved one has a bank account with only their name on there and you have no access to that account, I can't help you purchase an annuity because your power of attorney limits your authority. So at that point, we're stuck and we can't do this gifting option. So that's something also to consider with the power of attorney is updating them with the proper language for unlimited gifting and trust creation, which I'll talk about later. Okay, married couples. So there is an exception to the gifting rules. You can gift between spouses and it's not penalized, but the problem is Medicaid puts everything into a pot and they split it down the middle regardless of whether it's separate or community property. So that doesn't really make sense to help the family because both spouses' assets are counted together. So we can't really benefit from that, but you can use the excess money over that $157,920 to purchase the annuity. You can turn that money into income to your spouse at home because remember the spouse at home can have income of any amount. So let's say you've got $100,000 in extra money, you purchase that annuity, and then all of a sudden spouse at home, they're getting a $5,000 a month income in addition to whatever they're already making until that annuity runs out. And then you've saved all that money and the spouse was immediately eligible because we took all that countable money and we put it into a non-countable asset, an exempt asset, which is that annuity. So another spending strategy that is able to work. Again, you preserved all your assets. You can make sure your spouse at home maintains that standard of living and preserved all that extra money that you otherwise would have spent down. But again, annuity costs, fees, and you can only do this if your financial power of attorney has that authority or maybe other family members already have access to all of your bank accounts and financial assets, which most people don't. Okay, the dreaded MERP. Everyone knows about Medicaid estate recovery. If I get Medicaid, Medicaid's going to come take my house. Yes and no. So what happens is Medicaid keeps that running tab of how much money that they've spent on your loved one, and when that person passes away, they'll send you a lovely letter letting you know that this is the total amount that we spent on your loved one, and we are very sorry for your loss, but we would like to be paid back. Well, for most families, what's left? If you've already spent down everything to help that person qualify, your house is really the only thing that's left other than a car. So most times families have to sell the home to reimburse Medicaid, or the value of the home is so low that they end up Medicaid just gets the value of the house anyway. So unfortunately for families, this leaves nothing left of passing down your assets to your children. So what are the exceptions to estate recovery? Surviving spouse. If the surviving spouse is still living, when the Medicaid recipient passes away, they drop the claim. It goes away. If there's a surviving child under the age of 21, this can happen if we have disabled persons who need assistance, drop the claim. Surviving child of any age, blind or disabled. This is my favorite. Unmarried child residing continuously in the home for 1 year prior to the Medicaid recipient's death. What happens when most adult children care for their parents? They move in. Stay living in your parents', exactly, hi Brett. You stay living in your parents' home even after they need care, right? Don't move out. Because if you're still living in the home after your parent has passed away, you can have that qualify as an exception to Medicaid. When they send you that letter, you fill it in. I'm an unmarried adult. Now, if you have to be unmarried, so if you're married, this won't work. But you fill in that information. Nope, I'm unmarried. I've lived here. You show your power bill, that this is your address and all of that. They'll drop the claim for the house. And that's it. Some other exceptions, if you have a sibling or direct descendant inheriting that homestead and maybe they're 300% below that poverty level. I've actually seen this work where we had a son who was he was on social SSI. He didn't make any income, bless him. So we were able to get the home exempt just because he was the only child left and was able to keep it that way. Sometimes also it's just not cost effective for Medicaid to go after the house. They have to have attorneys come in and do all the work, and it's just not worth it. So if it's just a low estate value of like $10,000 or less, or they're not going to get a lot of money, they'll drop the claim. But if there's a house involved, there's incentive there. But remember too that Medicaid, they are a probate creditor. They can only come after the house, quote unquote, in the probate process. They're like a hospital bill, a creditor, like a credit card bill. They come in line with everybody else, and they want to come through that process through probate. How do we avoid that? Avoid probate. How do we do that for your house? There's something called a ladybird deed or a transfer on death deed. I highly, highly, highly recommend everyone have this. Now, this might not work for everybody. So let's say you have 4 children and you're a single parent, and it's maybe not ideal to have all your 4 kids own a house together because they're going to be fighting, or maybe one can't afford property taxes, or whatever the situation may be. Sometimes transfer on death deeds are not the best option, but if you want to protect it from Medicaid, you're going to need to do this deed because it removes the home from probate. It transfers at death instantaneously. It's in a vested interest. So at that point, the home's now part of your your children's estate, and it's not part of your estate anymore. So what is Medicaid going to go after? There's nothing left. There's a car. They're not going to go after a car. That's not worth their time. So ladybird deeds and transfer on death deeds, they avoid probate in general, obviously. Like I have one on my house. So it's going to allow, if I pass away, my spouse is going to get the home, and then if we both pass away, our kids get the home. So now my kids aren't going to have to probate unless they want to, or there's another need for it. So if you've got sort of a simple estate, they can really, really save your family money later having to pay for probate, because probate can run anywhere from $3,000 to $4,000 with a will. So, and if you don't have a will, you're talking probably 2 to 3 times as much. So highly recommend having a will, regardless of how small your estate is. I have seen families have to probate for 1 bank account. They had to pay me thousands of dollars to get to 1 bank account because they didn't have beneficiaries on that bank account, and it was a singular owned bank account. So it was unfortunate, but it was worth their time. There was a significant amount of money in there, so that's fine. But please consider doing an estate plan, or at least talking to some attorney. It doesn't have to be us. Please talk to somebody about checking your will, checking your powers of attorney, and seeing if this type of deed could really help your family, not only now, but for later, to save money in probate. Okay, so my biggest advice today, please don't wait until it's too late to update your financial power of attorney, because you do have to have capacity to execute a new power of attorney. If you have a dementia diagnosis, this does not mean that you are now ineligible to make your own legal documents. That's not the case at all. When you come see an elder law attorney especially, we understand capacity can ebb and flow depending on how you're feeling that day. UTIs for women, if women have a UTI and maybe it's undiagnosed, they can sort of exhibit those dementia symptoms, or it can be exacerbated. But please keep in mind that if you have capacity, when you meet with me and you understand the nature and consequences of what we're talking about, what you're signing, that's all I need. And as long as when you come back to sign with me, your capacity is still good, we can sign. It's okay if you have moments of incapacity or it's starting to wane, but it's always better to do it as early as possible, because remember, if you have children, other adult children who maybe don't want one particular child to be in charge, there might be an accusation of, oh, that power of attorney is invalid, oh, that will is invalid, and they might try to overturn that later or declare them void. So the earlier the better is the best news there. Okay, standard form online. You don't need an attorney to do a power of attorney, okay? You can go online right now at the Health and Human Services, hhs.com, Advanced Directives. You can get your own power of attorney. Statutory durable power of attorney is your financial power of attorney. They also have a medical power of attorney and a directive to physician. You might know that as a living will. Here's the problem, though. Those are the standard Texas forms. They don't have special language on them for unlimited gifting that we can really help families to protect those assets, to purchase annuities, to do a ladybird deed. They also don't have trust creation. So if we need to do that special trust for your income to help that family to qualify, we're stuck. So the standard form is awesome, but if you need Medicaid later, we might be in a pickle trying to protect your estate. So just keep that in mind. But you can go do that right now, get a notary. Mobile notaries can come to your house if you're disabled. You can get that done immediately, especially if you're in an immediate situation where you have a health crisis. Those can be very helpful. But I do recommend, especially for the financial power of attorney, you might want to have an elder law attorney at least look at what you have or do one for you if Medicaid's going to be in your future, simply because of these problems that we can run into. Springing versus immediate. Oh, another I wanted to point out, joint on accounts. What I mean by that is we had a client who was joint on with her daughter on all of her accounts. And she insisted, I don't need a power of attorney. My daughter's on everything, we're fine. Later on, mom needs Medicaid, daughter comes back to us and is asking for help with qualifying for Medicaid. Oh dear, we have no powers of attorney. Well, what are we looking at for mom's estate? Oh no, we have a life insurance policy with $3,000 in there. Well, mom can't have more than $2,000 in assets to qualify. So daughter had to hire a guardianship attorney and go through a guardianship process through the courts to get guardianship over mom to sell that life insurance policy. All of that money just to take care of her mom to get her into Medicaid and nursing home. Had she just had a power of attorney, we would not have been in that pickle. But so it's just little things like that that you don't think about that you might run into later is good to start planning now. So springing versus immediate. So you'll have the option on your power of attorney to make it effective upon disability or incapacity. So a doctor declares incapacity, then it's effective. Or it's immediate, where it's just effective right after you sign it and have it notarized. I do not recommend a springing power of attorney. The odds of you finding a doctor who can sign off incapacity when you need it in an emergency or crisis situation might be small. So you don't want to be put in that position or have your family put in that position. So I recommend that it's effective immediately upon your signing. If you're a little uncomfortable about your loved one having access to that power of attorney right away, just keep it safe. Keep it where you have control over it in your home. Please don't put it in your safe unless your loved ones have access to your safe. Please don't put it in your safety deposit box. That's like Fort Knox trying to get in there. If you have an emergency, the bank is just not going to have it. So make it to where it's safe but accessible. And trust creation, as I mentioned, it's good to have trust creation powers on your financial power of attorney so that your agent can go ahead and create that Miller Trust for you later. And unlimited gifting on the standard powers of attorney, it maxes out at the federal tax exclusion amount for gifting, which this year is only $19,000. I can't protect your estate very much with $19,000. I want to be able to protect your house, protect all your extra assets. So it's good to have that unlimited gifting on your power of attorney. So we have special language that also allows us to specifically create a ladybird deed. So in case you don't want to do that deed right now, you can actually give your agent the authority to do it later. So at that time, maybe when Medicaid does arise, then you could do the ladybird deed at that time. Protect it from Medicaid and protect it from probate. And also purchase the annuity. So if you need to purchase an annuity and protect $100,000 of your assets, I can't do much with a standard power of attorney. Per person. Yeah, so per person. So gifting, so if I'm a married couple, I can give 19 and my spouse can give 19. But so it's total per person 19. Okay, so can you receive Medicaid? Yes. Well, I have seen people do ladybird deeds on their own. I do not recommend it because there is very specific language that needs to be in that ladybird deed. And if you do it wrong, it could accidentally be a gift deed, which means you've gifted it right now, and then that person is now the official owner. Oops, I've seen that happen. You can also mess up the language where it's not effective, and so it's basically a void deed. So when the time comes, it's just not, it doesn't work. Yes, so it does vary state to state. So ladybird deeds are only allowed in 5 states. Texas is one of them. Most states do, I know, most people don't realize that. So ladybird deeds specifically. So there's a ladybird deed and there's a transfer on death deed. Most states do have a transfer on death deed. So I'll give you a little overview of the ladybird deed. It's a little bit different in how they work. So a transfer on death deed, you can add a contingent beneficiary. So for example, I want my spouse to go, I want my house to go to my spouse when I die and then to my kids. So that's a contingent beneficiary. The ladybird deed doesn't allow that. It's to that person or to 2 people equally. It's not to this person or to this person or then. Exactly, yes. So with a ladybird deed, you have to be very careful if you're married. There's been a lot of court cases on this. So whenever you have a married couple on a ladybird deed and they both are gifting, let's say to their child. Well, let's say husband dies. Well, husband's interest immediately vests to that child. So technically you have the child owning half the house and mom owning half the house. Now there's homestead protection laws in Texas, so the child can't force mom to leave or do anything with the house, but that could become a problem. Let's say mom wants to sell the house. Oops. Now you have to get consent from your child to do that. You want a mortgage, home equity loan, all of that, you would have to get consent from the other owner. So that is a problem. No, you would never put a minor on a deed. Oh no. Yeah, if you have a minor, there's other ways to do that. You could do a deed to trust where you have like a homestead trust. Oh, I think we lost connection there. We lose power? Yes, I believe Florida's a state. I don't know all the states on top of my head. Oh, thank you, nice. We lost power momentarily. We're back. Okay. So yes, ladybird deeds are awesome. One thing I do like about ladybird deeds is that the persons that you gift your home to, if that person predeceased you, that interest goes to their estate. So it's not lost, whoever their estate would be. Here's the problem. What if their will says their estate goes to their spouse? Do you want your daughter-in-law having your house? Maybe not. So a transfer on death deed might be good because a transfer on death deed says it goes to this person. If this person dies, it goes to the next person. So it allows a little more control. But there's a 2-year clawback period with transfer on death deeds. And under statute in Texas law, it says that creditors can pull that house back into probate if they so choose. I've never seen it done before, but it technically is allowed. Okay, so I'll finish up really quick. So if you want to receive Medicaid long-term care outside of the home, so let's say in the home or in a nursing facility or assisted living residence, there's something called the STAR Plus waiver program where you would have to qualify the same way we talked about today. All of the same elements apply. You actually do need that level of medical necessity, skilled nursing home care to qualify and have that care at home. But with all of these new changes coming about with Medicaid, this program is sort of up in the air of whether or not it's going to be sort of viable for clients to be able to access. Another thing that we found out recently is that Medicaid only pays their healthcare workers to come in around, I believe it's $11 an hour. Used to be, you would just sort of slip that person some money and supplement that money so that you can have that trusted person stay even though they're not making very much with Medicaid. That's illegal to do now. It's actually a jailable offense. You can go to jail if you are supplementing your Medicaid healthcare worker that's coming in. So since you can no longer supplement, what is the incentive for these wonderful Medicare workers to stay working for Medicare if they could go work private pay and make 3 times as much? So the problem I'm seeing with clients, they cannot get someone to come in. They get qualified for STAR Plus waiver, awesome, we're on it, we're ready, and then they can't get healthcare workers to come in, and they're stuck. So they end up having to move their loved one into a nursing community or nursing home. So it can be a problem, especially with all the new changes with Medicaid that are going to be coming later this year and next year. It's kind of up in the air. But just as an overview, you can do what's called consumer directive services. So you can, let's say you have your niece who say, I'll move in, I'll take care of you, you can actually have your niece qualified as a Medicaid caregiver, and they can start getting money. Now, granted, it's their Medicaid pay rate, but they're going to be living there anyway, paying for you anyway, or taking care of you anyway. Why not get paid? So you can have them approved as a Medicaid caregiver. Spouses don't apply for that. It can only be friends, family members, things like that. Again, there's a same qualifications as a nursing home care applicant. Here's the problem with the STAR Plus waiver program. You go on what's called an interest list. You call in, you give them your information, and then you wait. It can be months. I've had clients waiting years for the call, saying, okay, are you ready for STAR Plus waiver? So if you're needing care right away, sometimes it's just not attainable to wait that long. So that's also something to consider. And again, the current status of this program is completely unknown. We don't know what's going to happen with it. We can still try, because obviously our goal is to have our loved ones stay at home. We don't want to have to go to the nursing home route. There's the day health centers that are here. There's other options. There's care homes. There's things that we can do to help your loved one get care and not go the nursing home route. But I just wanted to prepare this presentation so that y'all understand it's not unattainable to get Medicaid nursing home care. We can protect your assets. We can help your family to move those assets to your children if your powers of attorney allow it. There's things that we can do. And you don't have to be destitute to qualify. You can have a very sizable estate and still get nursing home Medicaid. So just keep that in mind. But if you have any questions, I have my personal email on here, apuckett@assisting-seniors.com. If you have questions for us, it's probably better that you call the office than emailing me, because I don't know how long it'll take me to get back to you. But I will do my very best. Since they're going to give you a copy of this presentation, if you want to call with questions, please feel free. Even if you don't need help with Medicaid, even if you have questions about, referrals for other attorneys, we're always able to help. Call our office. We're happy to do it. But anyway, I want to thank y'all for your time today and your attention. Thank you so much.